do that, the estate is in debt to the daughter or to other people that you're interested in giving part of the estate, even though they don't deserve it according to original Din Torah, there's an enormous debt to them and you won't be left with anything. So if you're not, so you'll obviously choose to give them their portion and receive your portion too. Because if you have to choose between receiving nothing and receiving nothing versus receiving something and giving part also to the daughters or to whoever it is, or so you'll obviously choose to divide it according to the will, and that is the second halachic supplement, which is added on to the will, so, to make it halachically applicable. So these are the two solutions we talked about: matana mechaim and shtar chatzi zachar. Now there are different versions of how to write the shtar chatzi zachar. The original version is of the Nachlas Shiva, which is used very commonly. The Nachlas Shiva was a rabbi lived about 400 years ago, and he wrote it a nusach of shtar chatzi zachar. A lot of the rabbis just take it right out of the book and give it as a supplement to people to use. What we do nowadays is we use not only the shtar chatzi zachar, we use both. Also the matana mechaim and also the shtar chatzi zachar, both of them. There are different versions of who you create the debt to, and you admit, I received the loan from so-and-so. Who do you do it? Do you designate or you specify the people in the will who want to you want them to receive a significant amount of your estate, or other people? There's a lot of nuances here, but we don't really have time for all these little details. But in general, these are the two solutions, the halachic supplements that we do in one document that makes the will halachically applicable, and there's no problem of gezel. And also, even if you take it to Din Torah, the Din Torah won't say divide it according to the original Torah law, because all what you wrote in the will is halachically applicable, and the Beis Din will also say halachically you have to divide it according to what is written in the will. And that way you create a situation where there's no contradiction between the way the will would be probated in a regular court and the way it would be probated in Din Torah. And therefore, even if it is taken to a regular court and divided according to what's written in the will, it would be divided the same way halachically too. It would be taken to Din Torah, so there's no problem of gezel. And that way also you minimize, you take down to the minimum the chances of dispute, because whichever way you take it, whichever your court of law you're going to take it to, the result is going to be the same result anyway, so there's no point arguing about it, because whichever way you take it, it's going to work. So that is the way the halachic will works. Lemaisa, the way we do it, at least when we work together, offices at Coven and Greif offices, Yaakov Greif and Pinchas Cohen and myself, when we do it together, we actually create two documents. There are some lawyers who do halachic wills in one document, but as Yaakov will explain soon, we find it's better to do two separate documents, because you don't want, especially if you need to probate a will in Chutz La'aretz or even in Israel, for various reasons, you don't want the secular court or the Rasham Yerushot or wherever it is taking care of the wills starting to mix up with halachic all kinds of halachic jargon and words that it doesn't understand, and you start saying, well, what does this mean? Is it a will? Is it not a will? It's really a present. Maybe it needs to be taxed. Maybe it doesn't need to be taxed. You don't want all that mix up, and therefore, in the lechatchila situation, you're going to take the secular will and take it and use it, and if it happens to be a dispute, or if there's arguments if it's halachically okay or not, you have the halachic will that actually refers to it and supplements it and makes sure it's perfectly, also the legal one is perfectly okay. So that's the way we work it with, we do a legal will, and beside it, the halachic supplement which refers to it and makes sure that everything that's written in the legal will is also halachically applicable. There's no problems of gezel, and making sure that the result will be the same result, whichever court or whichever way it's interpreted from a legal or halachic perspective. That's the way we work it out. So this is really the first part of the lecture, and now I want to ask Attorney Yaakov Greif to fill us in with all the legal information. I want to Attorney Greif is, I understand, a Harvard graduate from a lot of years ago, and is dealing already over 30 years with Israeli and American law. And I can say from the experience of working with office in general, and also Yaakov personally, I'm learning so much from a legal perspective. And there's so much to know about laws in the United States, in Canada, in Israel, different states. And as I already explained, also Israeli law, and understanding all these nuances. And it's some very important things to understand, to fill in. So to understand it from a legal perspective. So I'll give Yaakov the floor to fill us in with this, and we'll take questions after this second part of the lecture.
Thank you very much. Thank you everybody for coming. I just want to introduce my partner Pinchas Cohen, sitting in the back there with your arm. We do this all together. So I guess what I'll tell you where I'm going with the stuff that I'm going to talk about in my lecture. I'm mostly interested, for tonight at least, in the special problems that Dati people who came to Israel from Chutz La'aretz encounter. And that's mostly what I myself have been doing. As the Rav mentioned, I graduated from Harvard a long time ago, 1980. And I practiced law in New York for many years. And then I came on Aliyah and I practiced here for about 10 years. And then I went back to California for 10 years, and now I'm back here. So I've practiced in several different jurisdictions and several kinds of jurisdictions. And I found, after all these many years of practice, when we opened our office about 5 years ago here in Ramat Beit Shemesh, we found that one of the main things that people came to us for, which at that time was something we knew a little bit about but hadn't done a whole lot of practice in. In fact, I probably knew the Halachic side better than I knew the Israeli legal side at the very, very beginning. But people came and said, look, we're Dati, we want our estate plan to work according to Halacha, and oh, by the way, I have a house in Florida, and I have my apartment here, or even maybe it's not even I have a house in Florida, but it's my parents still have a house in Florida, and Ad Mea V'Esrim, when my parents pass away, I'm going to be inheriting my parents' house in Florida. And what do I have to do? Do I need 3 wills? Do I need 2 wills? What could I do? So we started this crash course. We went to many shtalmuyot and lots of shiurim, and I switched my chavrusa from Hilchos Shabbos to Baba Basra and Choshen Mishpat. And we started really getting interested in this because we found that it was something that this community really needed. So, this has now become one of our fields of expertise, and we've done dozens of these wills, as the Rav pointed out, and we've talked to a lot of Rabbanim, and we've started working with the Rav in order to try to find solutions that are right for this community. And I'll just mention that the Rav's theme and my theme, Pinchas's theme, is pretty much the same. It's you don't want to leave your kids with a balagan. You want to write something and you want to set something up so that it'll be clear what you wanted. Your children will understand why you wanted it, and they won't be faced with ambiguities or difficulties, not in halacha and not in secular Israeli law, and not in the law of the other jurisdictions where you maybe still have some ties. Even though you've made aliyah, you still have some ties there, and you may have to transfer the title to property in these other places. So in the first part of my remarks, I want to talk first about general problems that every Dati person who comes on aliyah from an Anglo-American place like South Africa or the UK or any state of the United States, when they come to Israel and they get into the Israeli system is kind of a little different in many ways from what you may be used to. And so there's just a few problems that come up, even if you've completely severed ties with where you come from, and you have no more property there, and you don't have enough money to have to pay estate taxes in the United States, and you've been away from the United Kingdom long enough, more than 3 years in most cases, so that you don't have any responsibility for inheritance tax in the UK. You've split all those ties up, but you still need to think about things that are different here from the way they were in the jurisdiction you come from, because you may make assumptions that aren't correct. And then in the second part of the lecture, I'll talk about a few things that have to do with people who still have ties to Chutz La'aretz. For example, part-year residence in Chutz La'aretz, or even the possibility that you may be inheriting that house in Florida from your elderly parents. All right, so taking off on what the Rav had said, why you need an Israeli will, you don't want to put your heirs into a position where they have to violate the law of Gezel in order to carry out your wishes. Which if you say, which, as the Rav pointed out, if you leave it to the secular Israeli law, intestacy, inheritance law, which dictates where your property goes if you pass away, and, you know, then you have daughters, and the daughters are taking according to the inheritance law, but it's not valid in halacha. So then the daughters are put in a position where they're stealing from their brothers, even if it was what you wanted. Whereas if you write something down, then you've expressed what you want, and you've expressed it in a way that is valid in halacha and won't turn it into gezel. And by the way, I always like to point out to people, because I think most of the people who come to our office are people who feel, as I feel about my family, that in most instances, they will try to get along. You know, we have lots of horror stories, but I would say they're not the majority. I would say the majority of the situations, there's cases where the brothers and sisters get along. Oh, I don't have to worry because the brother will just want his sister to get something because he knows that's what I wanted. That may very well be true, but you have to also, when you're standing up here in a position of wanting to make sure you don't leave your kids a balagan, you have to account for the possibility, at least, that brother may not be able to reach some kind of compromise with the sister and be mochel on his rights, be mevater on his rights. He might not be capable. He might be underage and incapable of consenting to an agreement where, you know, everyone's nice to the sister. He might have creditors who are after him and saying, no, you can't give up this money, that's for us. Or he may be married to somebody who's pressuring him not to give up on his rights. In other words, even though you feel that like your children get along with each other, they may not be in control of their own destiny when the time comes that you're gone, and you can't intervene. So if you haven't written a will, you're leaving things more open for machloket than they would have been otherwise if you had expressed what you wanted to. So you get to tell your children what you want, and you get to explain the reasons why you want it. And Israeli courts anyway, according to the Piskei Halacha that I've read, and according to the discussions I've had with professors and dayanim and judges, they do tend to try to get people to carry out the wishes of the parents. And in cases where the parents have said why they want to do something, they tend to follow it. It gives strength to what the parents said they wanted to do because they understand the reasoning. I heard a story recently from another lawyer who said that they had a case where a man who was in his second marriage had disinherited his wife, apparently. In the will, he left to his wife, he had a bunch of apartments, and he left something like one apartment to each kid, and his wife got nothing. And she was upset, and she sued, and she said, you know, how come I'm out? How come I have nothing? And eventually, what turned out to be the case, after they dug into it, this was one of the lawyers I think it was the lawyer for one of the kids, but I don't remember. One of the lawyers who was telling me the story said, after they dug into everything, they realized that the man who passed away he had been the CEO of some very, very huge corporation, and he was making some outrageous pension. He got some outrageous pension amount a month, you know, $30,000 a month or something, some very, very, very high pension. And the pension was written in such a way that it only could go to his wife. It was not part of his estate, and it only went to his wife, and she was set for life for the whole rest of her life. She was going to get this $30,000 or something like this, very, very high monthly stipend from the pension, and everybody knew that, and apparently deceased husband knew that too, and that's why he felt she doesn't need anything. I'm cutting her out of the will because she doesn't need anything, and I'm giving the apartments to the kids, but it wasn't written into the will. And had it been written into the will, all the lawyers in the room were going, yeah, if it had been written, and there were some judges there too, if it had been written in the will, they would have understood this from the beginning, and it wouldn't have been a machloket. So we try to get people to write the will in such a way that it's clear and valid, and also that it explains what's going on. And the other thing we do in our office, and after this I'm going to stop plugging our Shita, but the other thing that we do in our office is that we try to make sure that what you have is an estate plan. We sit down with you and go, not just a will, not just a piece of paper with words on it. We sit and talk about what you want to have happen with your family in consultation with your Rav, the Rav, discussing, what are your wishes and what are your hashkafic desires for your family, and to put it all together and to create one big package. Sometimes when you go to lawyers, they do that, and sometimes they don't do that. But that's our approach. Okay, so another reason, besides the fact that we like to use this sort of overall holistic approach to figuring out what's going to happen with all of your property and your children and so forth, is, if a will. This is another reason why you need secular documentation. If a will is written according to proper halachic documentation, but there's something wrong with it in terms of the secular law, no court in Israel is going to be allowed to enforce it, even the rabbinical courts. And this horror story is the Avragil case, which was an important Israeli Supreme Court case. And what had happened in that case was, they had this lonely, elderly Holocaust survivor. He had no kids, no relatives, except for one brother that he hadn't spoken to in 30 years, completely estranged from him. And he wrote a halachic will, leaving all his entire estate. He owned, some assets, leaving his entire estate to the shul on the corner that he davened in for all these years. He was very close to everybody in the shul. He was very, very close to the Rav. And he wrote a shtar matana that left everything to the shul. This halakhically valid shtar matana, where he writes from today until 1 minute before my death, the typical regular shtar matana. And the rabbinical court said, yes, this is valid, and they gave everything to the shul. Now, when it got to the Israeli Supreme Court looked at the document, and they said, we understand this. We understand the halacha of what he's trying to do here. We see why it's valid in halacha, and we do see what you're trying to do. But the problem is that the only secular law category we can fit this document into is the category called will, in quotes, tzava'ah. And yes, we understand how it's trying to be a tzava'ah. But in order to be a tzava'ah under Israeli law, it has to be a valid tzava'ah, and it wasn't. Why not? Well, for one thing, the testator hadn't declared in front of the witnesses, this is my will. It's a formality under Israeli law that the guy who's making the will, the testator, has to, as he's signing the will, he has to say to the witnesses, this is my will, and then both witnesses have to be there, and they both have to hear him say that, and they both have to see each other there, and see him sign on the spot. You have to do that formality in order to ensure that the will before witnesses is really, really, really what he wants. He hadn't done that. There was another problem, though, also with that shtar matana that he wrote. Israel has a statute, it's section 35 of the Yerusha law, that's a very, very strict prohibition on participation by any beneficiary, anybody who's getting anything in the will, under the will, but a strict prohibition on any beneficiary participating in the drafting of the will. He can't be an aide. He can't be the guy who talked the guy into writing it this way. In this case, who had drafted the contract and who was one of the aidim? The Rav of the shul. And they said, we're very, very sorry, but everything has to go to this no-good brother over there out there somewhere that we know that Mr. Avergil didn't want the brother to get anything, and we understand why. And it's very nice that he wanted it to go to the shul, and it's very nice that it's valid in halacha, but that wasn't enough by itself. It needed to be valid in secular law also. So the case illustrates the problem of what happens when you try to make this shiluv between halacha and secular law, but you don't consult carefully enough with people who know how to do both things. It also illustrates a potential problem that the Rav alluded to of what happens when a halacha document is brought before a secular authority in Israel or outside of Israel, and they start trying to interpret the halacha concepts according to secular law. There's a really, really good chance that they could get it wrong. And then you'll end up not having done what you're trying to do. In fact, in the Avergil case, the Justice of the Supreme Court who wrote the opinion was Justice Engelhard. He did understand the halacha. The way he analyzed the will, I think, was probably right in halacha according to my best understanding. But there was luck of the draw that he got that case. I mean, it could have been somebody who knew nothing about halacha who would have gone off on crazy tangents. And an even more scary possibility is what happens if the United States authorities get hold of this halacha will and start trying to interpret it as a gift. And this is actually something that I owe to a professor in America who's also a Rav, I conferred with him about this thing, and he started talking about how, Yaakov, do not let your client sign a document that has both halacha and secular law in it. Because if your clients sign a document that says they're giving a matana now, a gift to all their heirs, and the United States Internal Revenue Service gets a hold of that, and they see the word gift, or even if they have some Hebrew speaker translate the word gift, the word matana into gift, they're going to say, whoa, this isn't an estate, this is a gift. They have to pay gift tax on this gift. And the maximum amount of a gift to subject you to gift tax liability is around $12,000 a year per person. It's not $5 million. So that all of a sudden you'll be in a category where you're paying taxes on something that you thought you weren't going to have to pay taxes on because you thought it was an estate. And so, that's scary. So the people that I'm a Talmud of advocate separating the halachic document, as the Rav was speaking about, from the secular document, so that you're using the halachic document to validate what you've written in the secular document, but to the secular authorities who are going to probate your will and the tax authorities, the only document you have to submit is the now completely valid, according to everybody's view, secular will. I got to tell one more story here that I had in here. It kind of went with something I said before, but it's a really good example of why you need to be careful and to plan ahead. Even where you feel like the people in your family get along. The Plony case. The Plony case, well, there are dozens of Plony cases, but this Plony case was a case that involved a woman who had been born in Israel. She was still an Israeli citizen, and she'd moved to Holland and become a Dutch resident. And she came back to Israel and wrote a will, right? She came back to Israel and wrote a will in Hebrew that purported to dispose of her Israeli properties, the property she had located in Israel, and she wanted to disinherit one of her kids. She had one kid that she was completely estranged from, who lived somewhere else in the world. She hadn't talked to in many, many years, and she decided she wanted to disinherit her. Now, that's perfectly fine under Israeli law, but it was invalid under a Dutch law that prohibited parents from completely disinheriting their children. And eventually the Israeli Yerusha authorities took a look at this thing and said, okay, we've analyzed her situation. She's a Dutch resident. We understand what she was trying to do. We understand her ties to Israel. We understand that she was only talking about her Israeli property. She wrote her will in Hebrew. She used an Israeli lawyer. She wanted it to be kosher in Israel. She wanted to disinherit this girl because this girl had nothing to do with her for all these years. But you're not allowed to do that under Dutch law. And she was a Dutch resident, so we have to apply Dutch law to the interpretation of her will because she was still a Dutch resident, and they wouldn't allow that will to go through. What's the trick of that? The daughter never appeared. It wasn't the daughter herself who filed this complaint. It was the Apotropos HaKlali, the general Apotropos of Israel, who reviews the wills and takes a look and says, oh, wait a second, Dutch resident? We know this Dutch law about how you're not allowed to do this. Sorry, you're not allowed to do this, even though the girl wasn't involved. She wasn't involved at all. So it's important to... It's not enough to think that your kids will work things out because, you have to just make sure that things turn out to be kosher. Okay. So I think maybe I've already answered the question with these stories. Why can't I just download something from the internet? And there are lots of will forms on the internet. Use a secular form on the internet, tweak a little bit, and then, save some money by doing that. And the answer is because too many things can go wrong. First of all, the forms, most of the forms that I've seen on the internet, don't do what the people who come to us end up saying they want to do. They don't give the property to the spouse and then to the children. They have some other kind of, usually they give it to the spouse or the children. Or, for example, some of the forms that I've seen are forms that are meant to be mutual wills, joint wills that are signed both by husband and wife, but they don't take account of a very specific problem that exists in Israeli law for husbands and wives who sign wills together. Remember how I mentioned this very strict law that Israel has about how you can't cooperate or work with somebody else in the writing of that somebody else's will if you're going to be a beneficiary? So this is a strict provision that's in the Israeli Yerusha law that's different from the rules that we're used to in Chutz La'aretz. Like, most of us come from jurisdictions where there's already a rule that says a will that was signed by the testator under undue influence from somebody else is not valid. Like, somebody pressures the elderly grandpa to sign everything over to them, or grandpa's very, very dependent on one child who's taking care of him, and then he signs this will under the influence of that child, or maybe it's not a child, maybe it's a caregiver. Like, those kinds of laws we're familiar with from the places that we came from. Those already exist. But the jurisdictions I'm familiar with, and I'm admitted to the bar in California and New York as well as here, those jurisdictions don't have a rule that's like this Rule 35 that automatically says as soon as you've done almost anything in participating in planning the estate with the testator, you can't be a beneficiary. So you have to, most spouses we know who come to us have to somehow get around that problem because most people who are married do want to plan their estates together. They want to sit down together and figure out, okay, I want the candlesticks to go to so-and-so. No, don't you think they should go to so-and-so? Oh, yeah, right, okay, so-and-so. And, and I want, I want to get this and so forth. In other words, they're going to be a beneficiary and they're going to be a participant in choosing who the guardians are for the children, choosing who the executor is, choosing where things go, all these decisions, because that's how most married couples in this community that we've ever encountered, that's how they run their families. They discuss these things together. So, not too long ago, in the last decade, Israel enacted a revised provision, Section 8A of the Israeli Yerusha law, that allows spouses to plan a will together, plan an estate together, and write mutual wills. And so then they're allowed to do that, which is very good, because that's consistent with what most people want. But there's even a kvetch in there, because under that law, once the spouses have gotten together, enacted as a corporate body in making their will together, they can't change it individually. They can only make changes together. So what happens if one of them is gone first and the other one survives? She, and I'll say her she because most of the time that's the way it happens, the surviving spouse can't change the will. That's the default position in Section 8A. The surviving spouse can't change the will. Most of the couples that we encounter want the surviving spouse to be able to change the will. Why? Well, okay, so I go to Hishtalmuyot sometimes where the professors will say, well, what if one of my kids becomes a drug addict, and my wife sees that that's what's happened to him and doesn't want him to get a third of the estate because he's going to just run off and spend it in one weekend. I want her to be able to change things so that he doesn't get it. You know, he's fine now, but I don't know what's going to happen. I like a more positive view. Like, what if I pass away and I leave everything to my wife, and, you know, by the time she lives a lot longer than I live, and by the time she's ready to pass away, my kids are incredibly wealthy and don't need a dime from me, and certainly don't want an apartment in Ramat Beit Shemesh. I'd like her to be able to leave it all to tzedakah if she wants to. So, you know, those kind of changes, if you want your spouse to be able to make those kind of changes, or let's say you want your spouse to be able to make some changes, but not any changes that she wants. You know, you want her to be able to switch stuff around between the kids, but you want to make sure she only gives it to the kids and not to anybody else. So yeah, some people might want that. You have to write that into the will, and you're not going to find on the internet a mutual will that talks that over with you and figures out that that's what you want, and talks it over with your Rav to make sure that the decisions that you're making are valid according to your family's shita and halacha, so that it'll all be good. That's why you need the sort of the more comprehensive case where the lawyer and the posek work together to do stuff. Some of the other things that people may need sometimes that are specialized are, for example, trusts for special needs kids. You know, if you have a child who's a special needs kid who beyond the time when they're an adult, they're going to need somebody to manage their money for them. You might want to leave the money in trust for them with a trustee who's somebody that they know, that you know, that's trusted, that's going to take care of things for them. Another possibility we've encountered in a few different cases that's more common in our community than in other Israeli communities is the case where you know, you may have set aside money, or you may plan to set aside money to give to your kids when they get married or when they buy an apartment. And it may turn out that when you pass away, some of your kids have gotten that gift and some of them haven't yet because they haven't gotten money or haven't gotten married or haven't bought an apartment yet. So we've worked out formulas for different clients based on what they wanted to equalize those gifts, you know, to make sure that all the kids get roughly the same amount, even though some of them have gotten a lot more now and the others aren't going to get it until later. Okay, so I've got one more story where that's important to think about this kind of thing, where you have to make sure that you work out the interplay between the halachic documentation and the secular documentation. I think I mentioned earlier why I personally believe that it's not a good idea to mix the halachic documentation and the secular documentation into one document. Many lawyers disagree with me on that. They say it's simpler if you put it all in one document, but the problem is that, and in that case, if you put it all in one document, presumably one lawyer and one Rav are working together, and it's been done in a way that at least the halachic provisions and the secular provisions do mesh. I mean, they're in one document, and one person has seen the one document. The problem is that one person is a secular authority who misunderstands the halachic language that's in there, and then you have a will that's been turned into something ambiguous that may not achieve what you want. If you also do the documents separately, but the lawyer and the Rav don't speak to each other, you have a different problem. And that's what happened in this case that I found that happened in the Tel Aviv family court a couple of years ago. It was called Bet Nun versus Shin Nun. And here's the family. There was an 80-year-old mom. She had 2 sons and 7 surviving daughters. She had had an 8th daughter who had already predeceased her. Okay? So first, one of the daughters took her to a secular lawyer where she was not, she didn't have Alzheimer's or anything. She was with it, right? She had a little trouble making up her mind, as you'll see. But she went to a secular lawyer, and she wrote out a will that left everything, she left her apartment, that was the main thing. She had in equal shares to the 9 surviving kids. Secular will, 9 surviving kids. So then later the 2 sons found out about this, and they said to her, "No, Mom, Dad always wanted the apartment to go only to us, because according to the Din Torah, we're the only ones who were supposed to get a Yerusha, not those no-good daughters." So the sons, she said, "Oh, you're right." So the sons took her to a different lawyer who signed her on a secular star matana, not a halachic star matana, a secular star matana that gave the apartment only to the sons, right? Then she found out what that meant, which was that the daughters weren't going to get anything, the sons were going to get everything, and she said, "No, that's not what I want." So she had the daughter take her back to the first lawyer, who signed her on another star to be mevatel the star matana, and thereby reinstate the will. So we have now 3 documents. Or no, right, 3 documents. We have the first will, we have the star matana, and we have the star bitul star matana. But there's more. There's a 4th document. The 4th document was, she goes to a Rav, who signs her in front of witnesses on a halachic will, in the form of a star matnas bari, that gives the apartment from today and a moment before death to the 9 kids, plus one more 1/10 share in memory of the deceased daughter that went to tzedakah. So it was almost the same as the secular will, but not quite, right? Because she was leaving a share. She was leaving a share to the deceased daughter. So they all take this thing to the Beit Mishpat L'Inyanei Mishpacha in Tel Aviv, the family court. And so what did the court do? Well, the court had to go through all these different documents to try to figure out what was going on. What the court did, first they said the first will that she wrote that left everything to the 9 living kids, that was no good. Why? You guys probably know. Section 35. The daughter had taken her to the lawyer and sat with her with the lawyer and had her write it out with the daughter there. The daughter was one of the beneficiaries, and that's usher. So that will was out. Okay, what about the second deed, the gift deed, in which she gave everything to the 2 sons in front of the second lawyer? That was also no good, because at the time she signed that deed, the lawyer, neither the lawyer nor anybody else, explained to her that the way that deed was written, it was irrevocable and she couldn't change her mind. I can guess why they didn't tell her that the thing she was signing was something that she wouldn't be able to change her mind about. It's probably because if they had told her that, she would have said, "Whoa, no, I don't want to sign something that's permanent. I want to be able to change my mind." But anyway, nobody explained that to her. And because nobody explained that to her, that one was no good either. So the withdrawal of her gift, that's document number 3, that they said was valid, because no one had explained to her that she would that on its face that second document she signed would be irrevocable, right? And she did revoke it. So since she thought she should have been able to revoke it, we're going to let the revocation stand. So what's left?